Then I'd like to... Not an FTA, no, not yet.
Not yet. It's the first step.
Then I'd like to introduce you again, Professor Rustambekova, the currently acting rector of the #1 university in Uzbekistan, the Tashkent State University of Law. I've had the privilege of having been there, having taught there in the past, hopefully again in the future. It's wonderful. If you get the chance to visit Uzbekistan, especially Tashkent, you must accept or use this possibility. Previously, Rustambekova has been the head of Department on Legal Protection of Interests of the Republic of Uzbekistan, meaning he's the #1 gentleman for all disputes in the past in investment law, in ISDS. So he has been handling these high-profile international cases for probably the past 10, 15 years for Uzbekistan. And I don't want to continue because it's a long list I could use for the introduction here, but I'd rather give the word to you, Rustambek. Great to have you with us.
Thank you so much, and good afternoon, dear distinguished participants. I'm honored and very glad to be here and to give some brief information about Uzbekistan and experience of Uzbekistan in the sphere of investments and raw materials. And I hope that will be useful for you to understand the progress which is ongoing in Uzbekistan and reforms. So we are very actively reforming our system, our legal system, and we always in reforming, first of all, would always learn the experience of Germany, because our civil code is based on the experience of Germany, and we are the civil law system country, so we are always cooperating with the lawyers from Germany, and as it was mentioned, we just signed the MOU with the Mартина Lютера University, and you are all warm welcome to Tashkent State University of Law. We will be very glad to see you in Tashkent, in Uzbekistan, and host you there. And you always could come to Tashkent State University of Law to conduct any lectures and trainings, and we are always open for such opportunities and cooperation. And if I will come back to my presentation, there's I think switcher. Here it is. Thank you. And I would like to begin my presentation with the expression of my gratitude for the opportunity to participate in this event and an ability to speak about a rather important matter for my home country, in particular Uzbekistan's mining sector, and both opportunities and challenges that foreign investors are faced with when investing in Uzbekistan and mining sector in particular. And the primary aim of my speech today is to offer insights into the opportunities, legal challenges, and arbitration experiences in Uzbekistan's mining sector, providing hopefully valuable information for potential investors, like legal professionals and other interested people in this topic. And as it was mentioned, I personally have the experience of participating, representing Uzbekistan in all the investment and commercial cases where Uzbekistan was a party to these cases. If we will give some brief overview. Some brief overview. So Uzbekistan is a double landlocked country, but which is situated in the center of the Central Asia. And in our country, the mining sector is one of the most important sectors for the economy of the country, and I say is a strategic one, being one of the key drivers of the economy. And we can say that a few facts about mining industry and natural resources of Uzbekistan. Uzbekistan is one of the world's largest producers of gold, ranked 9th, and of uranium, ranked 7th. And the EU countries, several EU countries are already discussing to buy uranium from Uzbekistan. Several weeks ago, the President of France visited Uzbekistan and discussed the possibilities to buy uranium from Uzbekistan and to bring it to France. Uzbekistan also produces copper, silver, coal, phosphate, molybdenum, potassium, tungsten, lead, zinc, and other minerals. Uzbekistan is among the 5 countries of the world for proved reserves of gold and among the 10, as it was mentioned, leading countries for production level. And I think for this year, Uzbekistan was the first in the first list among the countries who were selling the gold for this year. So we have a lot of gold resources. As for reserves and production of uranium, Uzbekistan is among the first 10 countries of the world. So if we will speak about the features and peculiarities of Uzbekistan's legal system in relation to the mining sector, despite being of the most essential sectors of the economy, or maybe precisely because mining has a quite robust, strict and peculiar legal framework, as you might know, Uzbekistan's legal system is based on civil law, as I mentioned previously. However, where Uzbekistan differs from many countries when it comes to the mining, even from those with the similar legal systems, is the fact that all the underground or subsoil resources in the country are owned by the state. Surface rights do not grant rights to natural resources in the ground and as such are clearly distinguishable from mineral rights. The law of the Republic of Uzbekistan on the subsoil, adopted in 2002, is the key law that regulates the activities of mining and metals companies in the Republic of Uzbekistan. Under this law, all subsoil resources are owned by the state, and subsoil use rights are granted on the basis of subsoil use licenses awarded to subsoil users through tenders or direct negotiations. There is a specific tenders for the which is organized by the state bodies, and there is specific regulations on that. Any transfer of subsoil ownership rights, including the right of use, to a non-state party is subject to approval by the Cabinet of Ministers, by the government of the Republic of Uzbekistan. And mining activities may also be conducted under the production sharing agreements, PCAs, within the framework of the law on production sharing agreements of Uzbekistan. And we also have the law on concessions dated August 13, 1995. However, as of June 2020, no concession agreements has been entered into force in the mining projects in Uzbekistan. So we don't use this law. Now we have like the production sharing agreements and the law on this, and like it is for the last, I think, 5-6 years, the concessions are just stopped signing concession agreements, and we are not using them. So this law, we can say, is not working at time. It goes without saying that such a rigid legal framework is viewed by some as an outdated and archaic system that hinders influx of investment to the mining sector, and the liberal measures should be implemented at least. And I would like to speak about some key disputes and our experience in relation to the mining sector. So in Uzbekistan had such a cases. You can see the 3 cases, but there is also this 4th one. I will also speak about that. And probably the most notable ones, the Newmont against Uzbekistan, and Metal Tech against Uzbekistan, and Oxus Gold against Uzbekistan. If we will say about the Newmont case, this was one of the first exit cases against Uzbekistan, and this case is only interesting since it was like the first such investment case, and the Newmont brought the claim against Uzbekistan before the exit. However, the matter was swiftly settled, and the exit proceedings were discontinued at the party's request on 25th of July 2007. And Metal Tech is a very popular case in investment dispute resolution, one of the first cases when the corruption became the main thing which stopped the jurisdiction of the case. So the arbitral tribunal found that they don't have the jurisdiction on this case because of the corruption in the investment. So that was the first one in the exit experience, investment dispute resolution experience, which is used at time by in all the investments where they want to say that there is a corruption and there is no jurisdiction of the tribunal. So they always use the Metal Tech case. So the Metal Tech initiated an exit arbitration against Uzbekistan and the Israel-Uzbekistan BIT for the alleged expropriation of 50% of its shares in a joint metal venture. And in 2008, the Uzmetal company, which was jointly established by investor and state-owned entities, was declared bankrupt by Uzbek courts following a series of actions on the part of Uzbek authorities, including the initiation of criminal proceedings against Uzmetal's management for alleged abuse of authority and the suspension of Uzmetal's exclusive right to purchase raw materials. And Uzbekistan's defense was that, as I mentioned, the tribunal lacked jurisdiction because Metal Tech's investment was made and operated corruptly and in violation of Uzbek laws on bribery. The tribunal ultimately found corruption to have existed and investment was thus established illegally, consequently rejecting Metal Tech claim. The next one is Oxus Gold versus Uzbekistan, and that was ancestral case. That wasn't an exit case. That was in Paris, and I think in this case there were Rolf Knipper as an arbitrator from our side. He was in the tribunal. And in August 2011, Oxus Gold initiated arbitration proceedings against the Republic of Uzbekistan. So you understand that this is the gold company. They were producing the gold, taking the gold from Uzbekistan, and they began the arbitration under the 2010 ancestral arbitration rules seated in Paris, alleging contract breaches and violations of the expropriation, fair and equitable treatment, and full protection and security provisions of the UK-Uzbekistan BIT, claiming damages of approximately $1.2 billion. The investor based its claims in relation to the alleged expropriation of its investment in the Amantal goldfields joint venture and the Hadija deposit on the UK-Uzbekistan BIT. The tribunal dismissed most of the claims, except for the claim for breach of the fair and equitable treatment standard, which was in BIT, and relating to the modification of the taxation regime applicable to AGF by the Uzbek authorities. In the final award, the investor was awarded with $10 million in damages plus interest. We always say that we won this case because it's just the 1% what they were requesting, claiming. They say that they won, yes, so de jure they won, but de facto we won the case. And I can mention that still they were not able to enforce this award. So they tried to enforce it in EU countries, in other countries, but they are not coming to Uzbekistan because Uzbek economic courts has an award against them on $10 million, and because of that they are not coming to Uzbekistan. And still the last proceedings we had in US courts, so they trying to enforce this award internationally. But this case is also one of the first cases against Uzbekistan when we had a third-party funding. So this case was funded by third-party funder, and they think that they won the case, but they still have they haven't received any money with the award, and so we protected our interests very nicely, we think, in this case, and still we are protecting this interest against the enforcement of this award, so it's still ongoing. We were discussing the amicable resolving of this issue, but it's an issue. Maybe I could tell about one more case. This is the Kim case against Uzbekistan. This is investor Vladislav Kim and others against Uzbekistan. That case began in 2013 in ICSID, and that was the longest case in Uzbekistan's experience and personally in my experience, which lasted for 7 years. And in 8th year we were able to resolve it amicably, but it was very long case and we lost the jurisdiction phase because the tribunal said that so there was a situation when we proved that the previous presidents, like the first president's daughter, got additional money to sell the factories, for cement factories, like illegally, and but the tribunal said this is not a corruption because she's not like a state member or some minister or etc. So we lost that case, but we were good in the second phase, in the merits, but we were able to resolve amicably, which were very nice, like result to both parties, and that was also a good practice to show internationally that Uzbekistan are ready to discuss and resolve the cases, investment cases and issues amicably. And in 2019 we resolved this case, so that was also a good point. And so in my practice that was the third case which we were able to resolve amicably and to sign a contract that we are like in one phase and doing the good things with the investors, and we're resolving the disputes without any war, etc. So if we will say what about now? Now Uzbekistan changed its legislation and improved the possibilities of investment and changed all its policy. Like from 2017, from 2016-17, we have a new president and a new policy and very openness policy. And the professors who visited Uzbekistan can prove it. The changes are really very good, and the reforms are going very good. And now, notwithstanding all that has been said, that the cases and all this that was before, and the situation occurred before the 2000s, the main of them, 2005, like all these cases. And now, more than ever, is interested in investment, especially foreign direct investments in mining sector in Uzbekistan, and there is a lot of investments from many countries and investors who are investing in the mining sector of Uzbekistan and doing a very good job in that sphere. And despite the fact that national legal framework regulating mining sector remains rigid, Uzbekistan is radically liberalizing its investment and investment protection legislation in hopes to attract more investments. Uzbekistan introduced progressive laws regulating investment activities. A new law on investment and investment activity was adopted, and I was one of the drafters of this law. And that is a really progressive law which gives all the guarantees according to the international standards in sphere of the investment. And this law consolidates a number of previous legislative acts relating to foreign investments, investor rights and obligations and investment activities. It encompasses and simplifies a wide array of investment-related activities and provides a solid protection to foreign investors and their investments. The new law defines main principles of the state policy in relation to the investments, such as the rule of law, justice and equality of subjects of investment activity, non-discrimination against investors, and the presumption of their good faith. Taking about mining, in particular, the resolution of the President of the Republic of Uzbekistan on measures for expediting attraction of foreign investments on geological studies and development of strategically important types of hard minerals, dated May 24, 2017, provides investors with simplified procedures for discussing potential projects with the State Committee on Geology and accessing geological data, subsoil deposits and prospective areas. So now it's the Ministry of Geology. They also participated in the Lithium Days and presented Uzbekistan's possibilities to invest in this sphere, in the sphere of raw materials and mining. In addition, Uzbekistan is currently creating special economic zones. We adopted a new law on special economic zones for the foreign investors, particularly those interested in mining sector, that provides such investors with special tax, currency and customs regime. Finally, Uzbekistan is actively engaging in negotiations with foreign partners in order to increase the number of BITs to provide robust protection for the international investors. And I can mention Uzbekistan prepared its own model BIT with the best practices, and it was mentioned previously, we included to the BIT, to our model BIT, the regulations regarding the human rights ecological obligations, which were also mentioned with the previous speakers. Overall, despite obvious shortcomings and drawbacks, Uzbekistan is actively improving an investment climate in the country, in particular for those investors that are interested in mining sector with a view mutual sustainable benefit. So that is the main things which I would like to bring to your attention. So as I mentioned, you are all welcome to Uzbekistan. We will be glad to see you, to host you, and to discuss any issues related to Uzbekistan, to its legal system here or in Uzbekistan. So thank you for your attention.